Good morning, this is your Kelso Report for Friday, October 28th, and I'm your host, Clark Kelso. Our featured case today arises in the area of tort law. Some 20 years ago, the California Supreme Court, in the leading case of Knight v. Jewett, reestablished and reformulated the doctrine of primary assumption of risk for California's tort system. There were arguments at the time that the adoption of comparative fault in California had rendered assumption of risk an obsolete defense. The Supreme Court disagreed, holding that primary assumption of risk was a complete defense to liability and negligence, because in a primary assumption of risk case, the defendant has no duty to protect the plaintiff from the particular risk which resulted in the plaintiff's injury. The court distinguished primary assumption from secondary assumption of risk, which covered cases where the defendant still owes a duty, but the plaintiff knowingly encounters that risk of injury. In these cases, secondary assumption of risk merges into and requires a comparative fault analysis. As for primary assumption of risk, the question after Knight v. Jewett has always been to determine the factual contexts in which it applies. Knight v. Jewett itself arose in the context of a game of flag football, a competitive sport. A companion case decided at the same time by the court, Ford v. Guin, involved a ski boat driver towing a water skier, which was described as a non-competitive sport activity. So from the very beginning, there was a question whether the doctrine of primary assumption of risk applied to anything other than sports. Now, over time, we saw that primary assumption of risk applied to water skiing, sport fishing, and whitewater rafting, but did not apply to recreational dancing or recreational boating. It applied to an organized, non-competitive mass bicycle ride, and it also applied to riding on a personal watercraft and motorcycle off-roading. Ultimately, a court applied the doctrine beyond sports to include participation in the annual Burning Man Festival, which the appellate court described as an activity which involved inherent risk of injury to voluntary participants. In yesterday's case, Amiscua v. Los Angeles Harley-Davidson, the Second District applied the doctrine to an injury which occurred during an organized, non-competitive recreational motorcycle parade sponsored by Harley-Davidson, known as the Pursuit for Kids Toy Drive. The parade involved several hundred motorcycles riding in a line on Los Angeles freeways and streets, and the plaintiff was injured in an accident when a van coming from the other direction, which was trying to turn across the parade, lost control, swerved, and hit the plaintiff. The plaintiff sued Harley-Davidson, among others. According to the court, primary assumption of risk applied because, quote, participating in an organized motorcycle ride along public highways with large numbers of riders is more similar to an organized bicycle ride than it is to being a mere passenger in a boat, a recreational dancer, or a lone motorcyclist. Like the risk of being burned while participating in the Burning Man Festival ritual, the risk of being involved in a traffic collision while riding in a motorcycle procession on a Los Angeles freeway is apparent, close quote. Accordingly, the court dismissed plaintiff's claim against Harley-Davidson, since there was no evidence Harley-Davidson had done anything to amplify the inherent risk of organizing and participating in a large motorcycle procession. Well, now to our one-liners, and we have quite a few of them today. First, in the area of attorney sanctions. In Miller v. City of Los Angeles, the Ninth Circuit reversed and remanded for reconsideration the district court's imposition of $63,000 in sanctions against the City of Los Angeles, resulting from its attorney's alleged violation of an in limine order, precluding the city, in a 1983 action, from arguing that the decedent was armed when he was shot by a city police officer. In its closing argument, the city's attorney made an elaborate presentation that, from the officer's perspective, here's why the officer might have believed the decedent was armed. At the end of this argument, he made a statement that the decedent had shot a third person inside a house just before being shot by the police officer. Plaintiff's counsel immediately objected. The objection was sustained, and the city's defense counsel immediately admitted there was no evidence that the decedent was armed at the time he was shot. The jury was given an admonition to ignore the particular statement in the closing argument. At a subsequent hearing, the district court imposed a $63,000 fine after making a bad faith finding. The Ninth Circuit majority reviewed the record and concluded that, contrary to the apparent view of all parties and the district court, the city attorney had not violated the in limine order. But the majority felt bound by the city's concession that the attorney had violated the order. So to justify its remand, the Ninth Circuit reasoned that the city had conceded the violation, but had not conceded bad faith, and that it was impossible for the district court to have correctly concluded there was bad faith when there actually was no underlying violation to begin with. Now, we of course have entered a hall of mirrors here with the majority opinion, and the dissent takes the majority to task for second-guessing everyone, including the city and the city's own attorney, on whether there was a violation. The only good news here is that the majority opinion recognizes the facts here are extremely unusual. Quote, "So this opinion's precedential value is probably limited," close quote. Well, I think we all can hope so. Next, in the area of criminal law, in Williams, United States v. Williams, the Ninth Circuit affirmed the defendant's conviction for advertising or offering to distribute child pornography in violation of Title 18, Section 2251. The defendant argued that the statute did not apply to him since he did not produce the child pornography which he advertised or offered to distribute. The court rejected this argument because the plain language of the statute did not require that the advertiser or distributor also be the one who produced the material. By its terms, the statute criminalized the advertising or distribution without regard to the identity of the producer. Next, also in the area of criminal law, in Schultz v. Tilton, a federal habeas case challenging a California conviction for committing lewd acts upon a minor under the age of 14, the Ninth Circuit held that a jury instruction regarding proof of similar uncharged conduct by a preponderance of the evidence did not violate the defendant's constitutional right to due process because the instruction included language making it clear to the jury that it could not use the uncharged conduct as the sole basis for drawing an inference of guilt, which would have violated due process, and that the ultimate standard of proof for making a guilt finding on the charged conduct was still the beyond a reasonable doubt standard. Next, an administrative law case. In Taylor v. Commissioner of Social Security Administration, the Ninth Circuit remanded the petitioner's denial of his application for disability insurance under the Social Security Act because the Appeals Council, as well as the ALJ, had failed to consider directly relevant medical and psychiatric reports regarding the petitioner's condition. So the court remanded to the ALJ for reconsideration in light of a complete record. Next, we have a state habeas case in In re Douglas, where the 4th District held that a 10-year delay in filing the petitioner's habeas petition rendered it untimely. The defendant pled no contest to one count of misdemeanor sexual battery in 1997. He was not informed prior to taking the plea that he would have to register as a sex offender. However, one day after sentencing, he was told, "You have to register." Yet, he did not file a habeas petition to undo his plea until 2010, when it appeared he was finally going to be prosecuted for failing to register. In non-capital cases, a habeas petition in California must be filed as promptly as the circumstances allow. And the 4th District held that the clock started running the day after sentencing when he was informed of the obligation to register, and there was no good cause basis for the 10-year-plus delay. The court dismissed the habeas petition. Next, an environmental law case in Southern California Gas Company versus South Coast Air Quality Management District. The 2nd District ruled in the management district's favor by deciding that the statutory phrase air pollution emission source in Section 41.511 of the Health and Safety Code applied to the owner of gas in a natural gas distribution system, and not just to the owners and operators of gas-burning equipment which receive their gas from the distribution system. By giving the statute this broad interpretation, it subjected the defendant gas company to the management district's extensive regulatory jurisdiction. In reaching this conclusion, which I think is a fairly broad and generous reading of the statute, the court deferred to the management district regulatory expertise. Now, there was a dissent here, which argued that the court should not have deferred to the district and instead should have applied ordinary rules of statutory interpretation, which suggested that the gas in a pipeline is not itself a source of air pollution emissions. Because of the interesting legal question of whether the management district's administrative action was entitled to interpretive deference, I think there's a good chance this case will be taken up by our Supreme Court. Next, we have an insurance coverage case. In Powell v. Williamsburg National Insurance Company, the 4th District held that an exclusion in a truck insurance policy for injuries or damages resulting from the movement of property by a mechanical device, unless the device is attached to the covered auto, that exclusion did not apply to an accident where the insured vehicle was struck by a hydraulic excavator which was in the process of loading broken pieces of asphalt into a different truck. The insurance company argued that the exclusion applied because the excavator was clearly moving property by a mechanical device when the accident occurred. But the court held that the exclusion applied only if the property being moved had something to do with the insured truck. In other words, if the excavator was about to place the asphalt in the insured vehicle and the excavator ran into the vehicle, well, that damage would fall within the exclusion. But the court was unwilling to expand the clause to cover situations where property was being moved with respect to other vehicles, noting that such a construction could lead to exclusion of coverage for the most random of acts simply because a mechanical device that was moving property was involved. There was insurance coverage. Next, an education law case. In Bullis Charter School versus Los Altos School District, the 6th District held, in a really exhaustive opinion, that the school district had failed to meet its obligations under Prop 39 to allocate to an in-district charter school facilities with, quote, conditions reasonably equivalent to those in which the charter school students would be accommodated if they were attending other public schools of the district, close quote. The evidence was rather overwhelming and demonstrated incomplete and inaccurate reporting of both the public school comparison group's facilities and the facilities offered to the charter school. In particular, the report grossly underestimated the facilities available to students in the comparison group, while grossly overstating what was being offered to the charter school. For example, the amount of unreported non-teaching space at the 5 comparison schools, it was underreported to the tune of over 1 million square feet. Oops, we just forgot about that 1 million square feet of space. Well, the 6th District sent the case back with directions to enter judgment for the charter school and to require the school district to make a new offer that complied with Prop 39's reasonable equivalence standard. We have one California Supreme Court grant of review from Wednesday involving charter schools. The California Supreme Court's grant of review in today's Fresh Start versus Los Angeles County Office of Education. And the case involves the question of whether a charter school, which had its charter revoked by the Los Angeles County Board of Education, was given due process in the revocation process. In particular, the 2nd District had held that due process did not require formal presentation of evidence or a formal evidentiary hearing before a neutral decision maker. Instead, facts could be presented at a normal hearing of the county board. My guess is that the court is going to have difficulty with the idea that a charter could be revoked based on facts informally presented and determined by a non-neutral board after only informal presentations of evidence. But we'll see what the court does with this case. And that's it for today's Kelso Report. Have a great day in the law.